Hearing in the appeal of Scottish Power UK Plc against Elaine Crozier or Veale and others.
Yes, Mr. Mackenzie.
I'm obliged, my lord. My lords, in this matter I appear on behalf of the appellants, along with my learned friends Mr. Campbell and Mr. Clancy, and my learned friends Mr. Milligan and Mr. Balfour appear on behalf of the respondents. There is one housekeeping matter, and that is a supplementary bundle was lodged to fix a defect in the Damages Scotland Act 2007 and to introduce some of the procedural rules from Scotland. Beyond that, if I may proceed by adopting the written case on behalf of the appellant. My submission will be in 4 parts this morning. I shall open, then I shall hand over to my learned friend Mr. Campbell, who will deal with the chapter on statutory interpretation. I shall then return to the podium to discuss the appellant's argument, and then finally deal with any rebuttal that is required following the discussion. So, my lords, when Mr. Crozier settled the pleural plaques claim, the liability the defenders had to him, and by extension his relatives, came to an end. No further proceedings were competent, having been barred by Section 4.2 of the Damages Scotland Act 2011. The appellants submit that the respondents' attempt to make a claim without the right to do so, and the courts below, is an error. The courts below erred in allowing the action to proceed. The exception under Section 5.1 of the 2011 Act is reserved only for persons who suffer mesothelioma and then discharge a defender's liability to pay damages for mesothelioma, and who then die from mesothelioma. Those 3 matters: suffer mesothelioma, discharge a defender's liability to pay damages for mesothelioma, and then die from mesothelioma.
So in this case, the second and third of those conditions were met, weren't they?
He died from mesothelioma,
and
but
liability for mesothelioma was discharged.
There was a liability to pay damages in the pleural plaques claim. No mesothelioma claim was ever made.
That would include the risk of it developing, wouldn't it?
A risk is not the same as an eventuality. So
he couldn't come back and claim for mesothelioma.
Well, he couldn't come back to claim a lot. No, indeed not. But
so in that sense, it was discharged. The liability for mesothelioma was discharged.
That's where I say no. There was no competent claim for mesothelioma open to him.
Sorry, had he contracted mesothelioma, he would not, while still alive, he would not have been able to come back and claim that, would he? I thought it was common ground that he couldn't.
Indeed, he did contract mesothelioma, and he couldn't come back to claim for mesothelioma.
Yeah, so the liability for mesothelioma was discharged, as my Lord Hamlin has said. It's only the first, as I understand it, of the 3 conditions that we're actually arguing about.
Well, I say that his liability had already, any liability that the defenders may have, had already been charged, and he didn't ever have a liability to pay damages for mesothelioma. There was no such liability.
I don't understand. I'm struggling. Before he died from mesothelioma, and the mesothelioma, we can take it, was caused by an actual remission of the defenders.
Yes.
Unless discharged, they were under a liability to him in respect of the mesothelioma immediately before his death.
There was no claim for mesothelioma. But he also he could not have competently brought a claim for mesothelioma.
Yes,
So
you're treating a liability as being conditional on the existence of a claim, are you?
Essentially so, my lord, yes. Because the pleural plaques claim had discharged any further liability there may have been.
For mesothelioma.
What, for anything?
Yeah, exactly.
Exactly. But I suppose the point where we're at cross purpose, and the fault is no doubt mine, is I am dealing with the exception for litigants who can claim under Section 5.1. So I suspect that where I gave a confused look was I hadn't understood the question properly. The exception under Section 5.1 is reserved only for persons who suffer mesothelioma and then discharge a defender's liability to pay damages for mesothelioma and then die from mesothelioma. And Mr. Crozier did not come into that category. He did not come into that category because he had already discharged his claim for pleural plaques. So he was not in the category of persons who could come within the exception under Section 5.1.
But it would still seem to me the most straightforward answer to the question that my Lord Hamlin has given to you is that you object, really, or your point is that he had to be suffering mesothelioma at the time.
At the time of his claim, he had to be, yes.
And really, that's what we're arguing about.
Indeed. Yeah. Not having previously discharged a claim, he had to be suffering from mesothelioma. So I'm grateful to both my lords for the intervention. So before the 2007 Act, mesothelioma sufferers faced the invidious choice of whether to die having been compensated but having excluded family claims, or to die without being compensated in order to preserve family claims. After that, the mesothelioma sufferer's estate would also be compensated. Avoiding this invidious dilemma was the mischief the provisions are designed to remove. So when I talk about the mischief, I'm referring back to the dilemma. This is the purposive meaning of sections 3 to 5 of the 2011 Act, read in the context, and we say that the headings are crucial to understanding that too. If there is an ambiguity, and we say there isn't, but if there were an ambiguity, any such ambiguity ought to be read in such a way that achieves the narrow but essential purpose of Section 5, to avoid the mischief and achieve the purpose of the exception. Now, against that background, I shall hand over to my learned friend, Mr. Campbell.
Yes, Mr. Campbell.
Good morning, my lords. As my learned friend has indicated, my submissions will address the principles of statutory interpretation that the appellant contends are relevant to this appeal. And as part of these submissions, I'll address the use of external aids to construction.
That's really what you have to depend on, isn't it? I mean, the words are against you. It's really the external construction that has to drive the interpretation that you're arguing for.
I will deal with the principles. My learned friend will deal with the application of those. I don't think it will be accepted that the words are against us when one goes through a purposive interpretation process. But indeed, the appellants do rely upon external aids as part of the submission. And the headline submission that I make, hopefully an uncontroversial one, is that admissible external aids can and should be considered as part of a purposive approach to statutory interpretation. Those external aids can provide strong pointers as to the meaning of a provision, and also may alert the court to an ambiguity, an absurdity, or an anomaly. And where there is such an ambiguity, absurdity, or anomaly, the admissible external aids can include those which satisfy the principles set out in the well-known decision in Pepper and Hart. And in covering this issue of principles of statutory interpretation, I'm very mindful that there's been considerable recent jurisprudence in this court.
Yes, I mean, you can take it, we're pretty familiar with this territory.
Well,
so
indeed.
you can take it quite quickly.
I will, my lord, and I don't intend to go at length to those recent decisions, but I do wish to look at a couple, just for the purposes of emphasising a couple of principles that the appellant says are particularly pertinent to this appeal, and also to deal with one specific issue which arises from the respondent's written case. And then Mr Mackenzie will address the application of these principles. Parties are agreed in their written cases that the correct approach to statutory interpretation can be taken from this court's decision in the dicta of Lord Hodge in Regina in the case of O against Secretary of State for the Home Department 2023, Appeal Cases 255. That's in the bundle, but I don't think I need to ask the court to turn it up. The most pertinent passages are cited in the more recent case of Bilta, UK Limited, in liquidation and Traditional Financial Services Limited 2025, 2 Weekly Law Reports 1015. And I would ask the court to turn up the case of Bilta, acknowledging that the court will be familiar with it. It's at tab 40 of the bundle. It starts at PDF 583, but the passage I would like to pick it up from is at the foot of PDF 590, at paragraph 23. It starts more recently. And there the court is referring to the dicta of Lord Hodge in the case of O. And going over the page, the court summarises, the court quotes paragraph 29, and just summarising that, it indicates the courts are seeking the meaning of the words used. It's the meaning of the words in their particular context. The statutory context is the primary source by which meaning is ascertained, and there's reference to the well-known words of Lord Nichols in Spath Home regarding the importance of that. But picking up at paragraph 30, what is said is that external aids to interpretation therefore must play a secondary role. Explanatory notes prepared under the authority of Parliament may cast light on the meaning of particular statutory provisions. Other sources, such as Law Commission reports, reports of Royal Commissions and advisory committees, and government white papers, may disclose the background to a statute and assist the court to identify not only the mischief which it addresses, but also the purpose of the legislation, thereby assisting a purpose of interpretation of a particular statutory provision. The context disclosed by such materials is relevant to assist the court to ascertain the meaning of the statute, whether or not there is an ambiguity and uncertainty, and indeed may reveal ambiguity or uncertainty with reference to venue. So pausing there, this details a process in which the court does not only consider the words of the statute, but should give active consideration to admissible external aids, such as those mentioned there, and the court should utilise what knowledge is gained from that exercise regarding the mischief and the purpose of the statute, and that can assist in the interpretation of the statute, including in identifying where there exists ambiguity or uncertainty. And then for completeness, finishing that paragraph, but none of these external aids displace the meanings conveyed by the words of the statute that, after consideration of that context, are clear and unambiguous and which do not produce absurdity. And in terms of the meaning of absurdity, I do wish to come back to that in a moment, because there may be a difference between the parties as to what is captured by that. But just turning back briefly, in Bilta, if one turns back a page at paragraph 20, and the first few sentences of 20 summarise the court's approach to statutory interpretation, and then there is reference to the case of Veale and the words of Lord Bingham of Cornhill. And if I can just emphasise those, Lord Bingham of Cornhill warned against giving a literal interpretation to a particular statutory provision without regard to the context of the provision in the statute and the purpose of the statute. He stated every statute, other than a pure consolidating statute, is, after all, enacted to make some change or address some problem or remove some blemish or effect some improvement in the national life. The court's tasks within the permissible bounds is to give effect to Parliament's purpose. So the controversial provision should be read in the context of the statute as a whole, and the statute as a whole should be read in the historical context of the situation which led to its enactment. 21 again details the words of Lord Nichols of Birkenhead and in Spath Home, and then 22, that is not to say there may not be circumstances in which the historical context provides strong pointers as to the meaning of a disputed statutory provision. So the appellant emphasises these, I think, uncontroversial propositions.
You don't want to say anything about 21?
I'm not skipping over 21. 21, I mention as the words of Lord Nichols, those were detailed within paragraph 29 of Regina O. So they are there. I didn't mean to not say anything regarding them. I acknowledge them, I accept them. The important constitutional point is recognised, and the primacy of the words in the statute are recognised after consideration of the context and going through the process of a purposive interpretation. What I wish to do now is turn to consider the role of headings. The court will see there's some emphasis placed on the heading to Section 5 of the 2011 Act by the appellant. There may be an academic debate arising between the appellant and the respondent as to whether what I refer to as the heading of Section 5 is appropriately termed a heading or a side note. It may not matter, but in my submission it's more naturally and accurately referred to as a heading. I think what used to be side notes in the legislation now appear in bold as headings at the start of each section and subsection. But perhaps more substantively, and I don't ask the court to turn it up, but in the case of R and Montilla, 2004 UK House of Lords 50, for your Lordship's notes, it's found at tab 53, commencing at PDF 967. It's particularly paragraphs 34 to 37 are relied upon for the principles relating to headings. And as I say, I don't need to take the court to that, but I would note three matters of relevance that were either observed or held by the court in that case. And the first of those is that the heading is contained in the bill as presented to Parliament. The second is that a heading is there for guidance and provides context for the examination of the parts of the bill that are open for debate. And the third is that when interpreting a statute, a heading can be used to assist in identifying the mischief which the section is attempting to remedy. So consideration of the heading with those observations in mind should form part of the purposive interpretation process. Dealing now with external aids and the status of them, in this case, there are explanatory notes, there is a Scottish Law Commission report of 2008, and there are, which fall within the admissible category as part of the purposive interpretation process as discussed in Bilta. There are also policy memorandums which are submitted to be of a similar status and admissibility, and parties seem to be agreed on that. They have been held by the Inner House of the Court of Session to be admissible external aids as part of the interpretation in order to identify the mischief. I don't need to take the court to that, but it was in the case of, and I'm going to use the acronym so I don't murder the Gaelic pronunciation, but CNES against Scottish Ministers 2013 Session Cases 548, and its paragraphs 47 and 62, which are relied upon. Those are at PDF 685 and 688 of the bundle.
They're specifically on policy memoranda.
Policy memorandum.
Thank you.
So in relation to the explanatory notes, the Scottish Law Commission report and the policy memoranda, it's submitted that each of those can and should be considered as part of the exercise of a purposive interpretation of the legislation. The written case also makes reference to legislative debates, and it's accepted that those are only admissible in circumstances where the pepper and heart conditions are met. And as the court will be familiar, one of those conditions is that the statutory provision is ambiguous or obscure or leads to an absurdity. So it's said here that if Section 5 is ambiguous or leads to an absurdity, then it's appropriate to see if there's a clear statement as to the meaning of the provision by an appropriate person in the legislative debates. As will be addressed by Mr. Mackenzie, the primary position of the appellant is that it's not necessary to revert to the legislative debates, but the secondary position is that there is an ambiguity or an absurdity present such that it's legitimate to do so. And this is where I come back to what is meant by an absurdity. The respondent's written case at paragraph 22 argues that an anomaly is of no relevance unless it produces an absurdity. And I submit that's not quite right. At paragraph 72 of the appellant's written case, reference is made to the decision in R on the application of Edison First Power Limited and the dicta of Lord Millett. And what is said there is that the courts will presume that Parliament did not intend a statute to have consequences which are objectionable or undesirable or absurd or unworkable or impractical or merely inconvenient or anomalous or illogical or futile or pointless. So, consistent with this, an anomalous consequence can stand as a relevant factor without also having to be considered to be absurd. Or looking at matters another way, as this court has done recently in the case of In Re JR 222, which is 2024-1 Weekly Law Reports 4877. It was detailed that the concept of absurdity should be construed very widely. And I don't need to take the court to it, but it's referred to at paragraph 76 of that decision, and the PDF page number is 848. What is said at paragraph 67 is that, in addition, the court should seek to avoid an interpretation that produces an absurd result, since this is unlikely to have been intended by the legislator. In that respect, absurdity is given a very wide meaning, covering, amongst other things, unworkability, impracticality, inconvenience, anomaly, or illogicality, with reference to R and McCool. So the appellant doesn't accept the submission, the accuracy of the submission made at paragraph 22 of the respondent's written case, that an interpretation which produces, in the appellant's submission, an unprincipled anomaly is only relevant if it also produces an absurdity. Such an anomaly falls within the wide definition of the word absurdity and can justify reference to legislative materials.
As to whether there is any anomaly here, is that a matter on which Mr. Mackenzie will be addressing us?
It is, my lord, and having trotted through those principles, my intention is, unless I can assist further, to pass back to Mr. Mackenzie now.
Thank you very much, Mr. Campbell. Oh, Mr. Mackenzie.
Yes, my lords. If I may start again by addressing my lords about common law liability. The reason for doing so is that the thread that runs through sections 3 to 5 of the 2011 Act is the concept of liability. And liability is not defined in the statute, so we go back to the common law. Now, in my submission, in a long-term tail a long-tail claim such as this, negligence occurred decades ago. Mr. Crozier was employed by the defenders between 1969 and 1992, and there was no liability at that stage. His right of action accrued when pleural plaques manifested themselves in around May 2011. That was when there was the concurrence of a wrongful omission and a personal injury, and thus all the elements of liability were present for the first time. In the inner house case of Aitchison, which we don't necessarily need to turn up, the reference is at page 575. Paragraph 33 deals with the concurrence of the wrongful omission and the personal injury, and thus the elements of liability being present. The concurrence of the wrongful act and the personal injury is significant for various reasons, in addition to the accrual of the right of action as such. Firstly, the limitation period starts. Secondly, the personal injury sustained determines for what the wrongdoer is liable. And this is a practical and not a theoretical matter. For example, the Fairchild exception applies to mesothelioma cases, but not those involving pleural plaques or asbestosis. The approach to damages is different. For example, provisional damages need to be considered in the context of a pleural plaques case that would not be considered in a mesothelioma case. Different heads of claim apply. Salatium alone might compensate someone with pleural plaques, but would not fairly compensate someone with mesothelioma. Because mesothelioma is inevitably fatal, Section 1 of the Damages Scotland Act 2011 would apply to compensate a person for lost years. That would not apply to a pleural plaques case. There are also likely to be services and maybe out-of-pocket expense in a mesothelioma case. The point the appellants wish to make is that while relatives have rights in mesothelioma cases, those relatives would not have rights in a pleural plaques case, all things being equal. Another aspect of liability at common law is the notion of the single or one action and res judicata. The usual rule is that a full and final settlement of a personal injury claim is just that, full and final. In paragraph 2 of their written case, the respondents accept that if a deceased person settles their claim for damages in respect of an act or omission prior to their death, there is generally no liability to pay damages to their relatives under Section 4.2 of the 2011 Act. The context of the single or one action rule and res judicata is also explained in the case of Aitchison at paragraph 32, and I don't think it's controversial. That is to be found at page 574 of 1250. A consequence of the one action rule and the application of res judicata is that a pursuer with, for example, pleural plaques should receive advice about provisional damages as an alternative to full and final settlement. And for someone with pleural plaques, there are advantages and disadvantages to both. full and final and provisional damages. If I may, we could turn up, please, paragraph 28 of the appellant's written case, which is at page 17 of the bundle. So, paragraph 28, I quote for convenience the section 12 of the Administration of Justice Act in 1982. And I would emphasize subsection 1, that this section applies to an action for damages for personal injuries in which, A, there is proved or admitted to be a risk that at some definite or indefinite time in the future the injured person will, as a result of the act or omission which gave rise to the cause of action, develop some serious disease or suffer some serious deterioration in his physical or mental condition. In those circumstances, reading short down to subsection 2, the court may, on the application of the injured person, order that the injured person referred to should be awarded damages, or the damages should be awarded to them, and B, that the injured person may apply for a further award of damages referred to in section B, subsection B below. And the court may, if it considers it appropriate, order that an application under that paragraph may be made only within a specified period. If we can read on to subsection 3, where an injured person in respect of whom an award has been made under subsection 2A applies to the court for an award under subsection 2B above, the court may award to the injured person the further damages referred to in subsection B below. And here I read on further to subsection 4. The damages referred to above are A, damages assessed on the assumption that the injured person will not develop the disease or suffer the deterioration, and that further damages will arise. Now, the reason for referring to subsection 4A is that there is an assumption that the injured person will not develop the disease. And this comes back to one of the questions I was asked at the opening about the difference between a risk and the eventuality. The risk triggers the provisional damages, but then provisional damages are assessed on the assumption that the injured person will not develop the disease.
Is it right that somebody in Mr. Crozier's position who enters into a full and final settlement with, when they have pleural plaques rather than provisional damages, is going to miss out on the opportunity when they do develop mesothelioma to claim for future loss of earnings?
Yes.
So they're going to suffer that detriment anyway if they go down this route, regardless of whether they've also cut out the ability of their relative to claim salation.
Yes, indeed. They will suffer that detriment, and that is the policy of the law. And that is why, when I say that there are advantages and disadvantages to an award of pleural plaques, that is one of the disadvantages of full and final settlement, is that it does cut off future damages. But that is a matter of choice for the person being advised. In the event that that provisional damages are taken, then all options remain open. There is a suggestion in the Respondents' written case that somehow there is an unfair, that the appellant is arguing that there's an unfair advantage that Mr. Crozier gained an unfair advantage, and I say that is not the case. If we can turn, please, to paragraphs 25 and 26 of the Respondents' written case.
Just before you go there, assuming that the pursuer in question does not go for provisional damages, so they go for the lump sum with pleural plaques, there will be, I assume, a potentially substantial claim for the risk of mesothelioma, which will include loss of earnings and the like, I assume.
So if somebody chooses to take provisional damages?
No. If they choose to go the lump sum route...
Oh, lump sum, I beg your
yes.
pardon.
So they're not going the provisional damages route. They will be compensated for the risk of the mesothelioma, which you would anticipate might well be a substantial claim.
They will be compensated for that risk, and there is the authority mentioned in the appellant's case called W against the Advocate General that deals with the formula for that. What happens, my Lord, is that the risk is assessed and compensated for as part of the salatium award. So a single award of salatium is given for the pleural plaques and for the risk of future diseases, including mesothelioma.
But there must also, I would have assumed, be some loss of earning.
No.
No?
No, and in this case, we can look at the statements of valuation of claim if we need to, but in this case, only salatium was awarded to Mr. Crozier, following the logic of the case of W, which is Lord Boyd's decision, that there's essentially a formula where one looks at the percentage chance of contracting mesothelioma, and then one multiplies likely amount of damages by that risk, and then that gets bundled into the...
Why is it just salatium? Sorry.
Yes, we're not hearing an appeal today against the decision in W, but it sounds rather dubious. I mean, pleural plaques, I'd have thought, wouldn't attract by themselves much of an award at all, because they're significant really as a sign that you are liable to develop a more serious illness. And so on, because
presumably the risk of mesothelioma is still quite low, is it?
The risk, again, it depends on the case.
Yeah.
But in my experience, the risk tends to be of 1 to 5%.
1 to 5.
1, 2, 3, 4, or 5%.
Yeah.
Which is why the anticipated loss of earnings doesn't feature, presumably, because that's too small a risk to entitle you to a loss of future earnings. Is that logical?
That seems to be the logic of W. And that has been the...
I have to say I find that very surprising, but if that's what the law is, that's what the law is. I mean, it doesn't seem to me, if you're ending up with a 5% risk of contracting mesothelioma, why aren't you getting 5% of the estimated loss of earnings? It just doesn't seem logical to me. And I'm afraid I'm not familiar with the ins and outs of this W case that you're referring us to. You say that rules out any loss of earnings claim for the... it's patrimonial loss, I assume. How's it described? What's loss of earnings?
Loss of earnings would be a patrimonial loss. Well, yes. All the likely future losses for mesothelioma would be estimated, including patrimonial loss, and they would then be rolled up into an award of salatium.
Oh, right.
So
but even if you only got 5%, it's obviously a lot less than what you would get if you took provisional damages and later went back to court and when you did have mesothelioma.
Indeed, sir.
Right, it's the rolling up into salation that may be causing me some confusion, I think.
Yes, they are not described as patrimonial losses in the full and final pleural plaques settlement.
Okay.
They are described only as salation. But just again, for the avoidance of doubt, that includes notions of the risk of all future losses.
I see, looking at W, it's based on English authorities and the Judicial Studies Board guidelines. So we might be opening Pandora's box if we...
There are two cases, my lord. There is both W and Harris. W deals with the provisional damages, and Harris then it's Harris that was the one the decision of Lord Boyd that followed the following year, and that then deals with full and final settlement. So I got my Harris and my W confused.
Oh, it's Harris, is it?
It's Harris.
Okay.
I've been corrected by my learned junior.
Right, thank you.
But one way of testing whether the consequence that you say is unreasonable is indeed unreasonable is to say, well, is it anything unreasonable with a situation where somebody who's an insurer who's settled what turns out to be a mesothelioma claim for 5% of what it's worth and gets that benefit should also get the benefit of not paying out salation to the relatives as a result of that settlement? And that doesn't seem obviously unreasonable.
Well, in the appellant submission, that would be unreasonable because that would allow for a second action by the relatives. And
well, that's contemplated if the settlement occurs when the person has mesothelioma.
In the appellant submission is that a second action by the relatives would not be contemplated when there is a full and final settlement for pleural plaques.
I know that's your submission, but what I'm saying is, given that it seems to me relevant that the insurer has already got the benefit in your situation of having settled the mesothelioma claim, or what turns out to be one, at a stage when it only had to pay 5% of what it was worth. And the question is, against that background, is it unreasonable that the relatives are not precluded, in the event that mesothelioma develops, from claiming their salatium, just as they would not be if the settlement had occurred at the time when mesothelioma had already developed?
I submit it would be unreasonable for this reason, that there are competing public goods in play. On the one hand, a person who has suffered a personal injury as a result of a wrongful act or omission should be compensated. But on the other, there ought to be finality to litigation. And that finality is a good in itself. There are many more pleural plaques cases than there are mesothelioma cases.
But the legislature's drawn a distinction here, which in one sense is unprincipled, because it's a policy-driven provision, isn't it? And the question is how far that policy of greater charity towards people who suffer from the horrible disease of mesothelioma goes.
That is a matter for the Scottish Parliament to...
Well, that's right.
Yes.
And it may be that they've answered that by saying that in the case of somebody who does develop mesothelioma, their relatives can still get the opportunity to claim salatium, regardless of when the full and final settlement has ostensibly occurred.
Perhaps we should deal with that then head on and look at the mischief, my lord.
Because, I mean, all we're arguing over here is whether the person has to have been suffering from mesothelioma at the time of the settlement.
Yes.
If they weren't suffering from mesothelioma at the time of the settlement, that's this case. If they were suffering from mesothelioma at the time of the settlement, then the relatives undoubtedly benefit from the exception.
If he was suffering from mesothelioma, yes.
Yes.
Yeah.
And there is no dispute that the exception goes that far.
Yeah.
The only dispute between my learned friend Mr. Milligan and me is essentially whether the exception applies to all persons who have settled a claim for an asbestos-related condition on the one hand and then die from mesothelioma, or whether it only applies to those who have settled a mesothelioma case, not having previously settled anything else, and then die from mesothelioma.
Well, it's not so much the nature of a case as whether they are actually suffering from the disease at the time of the settlement, because the settlement is evidently going to encompass liability for mesothelioma, whether the disease is currently being suffered or is simply a risk looking to the future?
There is no, well, it's expressly accepted that Mr. Crozier was not suffering from mesothelioma.
Yes, we know that.
Yes.
What I'm suggesting to you is that either is a perfectly rational policy for a legislature to adopt. It introduces some arbitrary distinctions, since people who've got lung cancer from asbestos fibres don't benefit from the exception, but a line has been drawn, and there's no obvious greater. It's not so obviously unreasonable to include within the exception people who go on to develop mesothelioma even though they haven't yet.
The unreasonableness, my lord, comes from going beyond the nature of the mischief, going beyond the nature of the dilemma that is only faced by people who suffer from mesothelioma when they come to settle their claims. It's not, the dilemma is not suffered by people with, for example, pleural plaques. So there would then, if the wider exception were allowed, that would allow an uncontrolled and, we say, unprincipled exception to what is a perfectly principled policy exception to resolve the dilemma that those suffering mesothelioma face. Now, if one looks, well, if one, my lords, recall the case of Black Clawson, it's in the bundle at page 631 to 2. This is the speech of Lord Reid starts at page 631. And what he says my highlighting's disappeared. Yes, looking at page 632 and letter B, and if I may, I will simply read that. It has always been said to be important to consider the mischief which the Act was apparently intended to remedy. The word mischief is traditional. I would expand it in this way. In addition to reading the Act, you look at the facts presumed to be known to Parliament when the bill which became the Act in question was before it, and you consider whether there is disclosed some unsatisfactory state of affairs which Parliament can properly be supposed to have intended to remedy by the Act. There is a presumption which can be stated in various ways. One is that in the absence of any clear indication to the contrary, Parliament can be presumed not to have altered the common law further than was necessary to remedy the mischief. Of course, it may and quite often does go further, but the principle is that if the enactment is ambiguous, that meaning which relates the scope of the Act to the mischief should be taken rather than a different or wider meaning which the contemporary situation did not call for.
Now, the important words there for this case may be if the enactment is ambiguous.
Indeed, it may be, but in my submission, that would also apply to any purposive interpretation of the Act too. But any Act should not innovate on the exception more widely than necessary. And the important words are the wider meaning which the contemporary situation did not call for. And the contemporary situation called for by the Scottish Parliament in 2007 with the 2007 Act was the resolution of the dilemma for those suffering from mesothelioma. It did not go further than that.
When Lord Reid refers halfway down just below letter C to the common law, does he include within that phrase plus any statutory alterations to it already made, or is he talking about the pure common law?
He's talking about...
So that in a case where Parliament hasn't previously intervened, the common law has some sort of status of unalterability beyond the mischief, which it wouldn't have if Parliament had already trampled all the way across the field.
My understanding from the reading of this case is that, and more generally, is that he was talking to the, speaking about the common law as altered by statutory law. So it's the common law as it stands, having been adapted by common law, by statutory law.
And this was about the Foreign Judgments Reciprocal Enforcement Act.
I mean, you might say that the headline purpose is the dilemma that you're talking about. But why isn't it equally valid to say, in line with the words that are actually there, that you're solving the dilemma for someone who has the risk of mesothelioma? Because they now know, they can rest assured, whatever we settle, our relatives are not going to be affected, not going to be disadvantaged. So although I can see that, you know, the easy way to sell this act, if you like, or to explain what's going on, is to focus on someone who has mesothelioma, but you would anticipate that it's equally applicable to someone who's got pleural plaques with the risk of mesothelioma, because they've also got a dilemma, which is if they settle, they might otherwise impact on their relatives. And so this act, your mind's put at rest across the board. If you've got mesothelioma or the risk of mesothelioma, you can settle without prejudicing your relatives. What's wrong with that as the obvious purpose behind the words that we've got?
Well, firstly, the Act did not envisage the exception applying to anyone other than mesothelioma sufferers. And on no account at way can Mr. Crozier be said to have been a mesothelioma sufferer when he had only pleural plaques. He cannot have been described that way. Now, taking my Lord's point about the Act being altered by, or the common law being altered by statutory provisions, the common law has been adapted by rules such as that dealing with provisional damages, which allow someone facing the options that Mr. Crozier had to either elect for provisional damages and keep all of his options open and take a slightly smaller amount of damages, or take a slightly larger award to compensate him for a risk which may not happen. Had there only been on the table the option of full and final damages, then perhaps there would be more force in the suggestion that he faced some sort of dilemma. But he didn't face a dilemma. He had options. And that's not mere semantics. He could keep his, the opportunity to obtain damages both for him and for his relatives open.
How does provisional damages keep the relatives' claim open?
Because of the 2007 Act reenacting the 2011 Act, no one in Scotland faces the invidious dilemma of having to choose to settle a case now and avoid the relatives' claims, or to not settle a case for mesothelioma so that the relatives could claim. On any view of the 2011 Act, the relatives will have a claim if somebody has provisional damages, then contracts mesothelioma, can return to court to seek damages for themselves, and then the relatives' rights will stay open.
Because of the Act, yes.
Because of the Act.
Yeah, but otherwise they wouldn't be able to, whether it's provisional damages or full and final settlement.
I'm not sure I understand what I'm saying.
Well, whether you go for provisional damages or a full and final settlement, leaving aside the Act, the relatives' claims goes with that.
If you take it on the appellant's submission, and the appellant's reading of the Act, if a full and final settlement is elected for, then the relatives' claims fly off.
Yes.
For if there is settlement for pleural plaques. If, however, there is a provisional damages settlement for pleural plaques, that allows Mr. Crozier to return to court if he contracts mesothelioma, and it keeps the relatives' claims open on any view. And that's because of Section 5 of the 2011 Act. No one in Scotland faces the invidious dilemma if they have mesothelioma. I should say if they have a claim for mesothelioma, as I've said. Now, it was, if I may, I was going to refer to the Respondents' written case and to paragraphs 25 and 26. This is at electronic, my laws may already be ahead of me, at electronic page 53. Now, what is said by the respondents is that one of the fundamental flaws in the reasoning in the appellant's written case is the implication that Mr. Crozier gained an unfair advantage in settling his claim on a full and final basis instead of accepting provisional damages. I think given the discussion we've had, there is no such suggestion by the appellants, nor could there be. The respondents accept that had Mr. Crozier taken provisional damages, he would have been in a much better position than turned out to be the case. Section 5 only preserves the relatives' rights in relation to claims for loss of society in Section 4.3b. It says it does not preserve the rights to loss of earnings or loss of financial support or services. Well, that is true as far as it goes. Section 5 does not. But if the return conditions following a provisional damages settlement allow a return for mesothelioma, then the pursuer in that case, the living pursuer, would be able to claim for solatium, for lost years, for services, and for any other reasonable losses arising. So I take exception to that. It is said at paragraph 26, more importantly, Mr. Crozier would have faced exactly the same dilemma as any person who contracts and dies from mesothelioma, simply at an earlier stage before all the risks are known, and I've already dealt with that, but I do say that is simply wrong. But for Section 5, settling his claim for pleural plaques would discharge any further claim in the event that he contracted mesothelioma. Well, that is true if one adds the words on a full and final basis. It is not correct if provisional damages are awarded. It then continues, even if he had provisional damages, he would simply have delayed the dilemma that the appellants recognise as the mischief. Again, that is completely wrong in my submission. Nobody in that circumstance who has provisional damages with a return for mesothelioma would face the dilemma.
You say, do you, that I think that part of the dilemma that makes, or was thought when the legislation was devised to make mesothelioma special, is the prospect of imminent death?
Yes, my lord. There had been a change in the procedure in Scotland. Chapter 43 introduced a personal injuries track in around about 2003. That speeded up the claims from some small number of years to about 12 to 14 months. So for the first time, someone with mesothelioma might have been able to achieve compensation within their lifetime. Before, it wasn't even an option because litigation was likely to last years and they would inevitably have died before then. With the introduction of the court reforms in 2003, that then allowed people to claim damages, but then the dilemma occurred that if they did that, if they elected for a swifter form of justice, then that would deprive their relatives of compensation because of the operation of the common law. as adapted by the 1976 Act. Yeah. And most litigants did not do that. They elected to keep their families' options open. It may be appropriate at this stage to turn to the policy memorandum as part
Can you
of
just help me? Let's just put to one side mesothelioma for a moment. I know it's difficult to do that. I'm just trying to get my head around the precise law in relation to provisional damages.
Yes, ma'am.
Say we've got pleural plaques, but what we're talking about is the development of asbestosis and not mesothelioma. So what we're talking about today is out of the window. What happens if somebody with pleural plaques gets an award, goes for provisional damages, and then suffers asbestosis? What is the position in relation to their relatives' claims if they've gone for provisional damages? What then happens in respect of the asbestosis?
If the only return condition was for asbestosis and not for mesothelioma, then the relatives would not be entitled to claim under Section 5.1.
Thank you.
Which is why, when one advises anyone under the provisional damages legislation, one has to be very careful about the return conditions.
Well, you would always include mesothelioma.
That is essentially the biggest threat.
Yes.
So, if I may turn to the policy memorandum. This is at page 374 of the bundle. Now, this policy memorandum is dated the 27th of September 2006 and is in respect of the Rights of Relatives to Damages Mesothelioma Scotland Bill that had recently been introduced, or was being introduced. Paragraph 2, having dealt with the nature of mesothelioma, it is said that there is no cure for mesothelioma, and once diagnosed, sufferers survive on average some 14 months. In the great majority of cases, the disease is associated with occupations where there was a greater likelihood of asbestos exposure, such as shipbuilding, construction, etc. We then continue by talking about the instance of mesothelioma rising.
Can I just check, because obviously this relates to the earlier legislation, but there was no comparable exercise separately in 2011, was there?
No, the purpose of the 2007 legislation was to repeal and then reenact the 2007 and other provisions, so that there was a global act dealing with these provisions. There had been, for reasons I'll explain, there was a consideration by the Scottish Law Commission of, amongst other things, the impact of the 2007 Act in fatal claims. Now, there is an accurate, in my submission, reference to the law as it developed, but if I may turn to paragraph 8 and read that under section 1.2 of the Damages Scotland Act 1976, the immediate family of an injured person is prevented from claiming damages on the death of that person if the deceased has already settled in full a claim prior to death for damages for his or her own loss. Currently, mesothelioma sufferers face the dilemma of either pursuing their own damages claim or not pursuing their claim before they die, so that their executor and relatives can claim awards which total more than the award of damages the sufferer was entitled to. Most sufferers, around 80%, are not pursuing their own claims in order not to disadvantage their families. So, it is then said at paragraph 9, there have been representations for some time to the Scottish Executive and the Scottish Parliament for a change in the law relating to the rights of mesothelioma sufferers' close relatives to claim damages for grief and suffering. campaigners on behalf of mesothelioma sufferers proposed an amendment to Section 1.2 of the 1976 Act, which would remedy the dilemma described at paragraph 8. That's paragraph 8 above. There's then reference to a Mr. McNulty, MSP, who did that. Now, if we can read on to paragraph 12, where it is written that the policy behind the bill is to remove the dilemma which mesothelioma sufferers find themselves in, as described in paragraph 8 above. The bill will disapply Section 1.2 of the 1976 Act so as to allow the immediate family of a mesothelioma sufferer to claim damages for NPL under Section 1.4, that's non-patrimonial loss, under Section 1.4 of the Act, where the sufferer has sustained personal injuries as a consequence of mesothelioma and dies as a result of those injuries, irrespective of whether the deceased has already recovered damages or obtained a settlement. The bill does not disapply Section 1.2 of the 1976 Act in relation to Section 1.3 of the Act, which relates to compensation to relatives for loss of financial support. So all that can be claimed is the non-patrimonial loss under that. The unique features of mesothelioma are described at paragraph 16, and we can read that short. If we can turn, however, to paragraph 18, this is something I've already alluded to but not expanded upon. Alongside the review of the wider law, ministers are taking this urgent action to address the problem which has arisen specifically for victims of mesothelioma. They have no intention of encroaching more widely into the law of damages without advice and recommendations from the Scottish Law Commission and the opportunity to consider and consult on these. Any extension in this bill beyond mesothelioma would be such an encroachment. Because there is no other class or condition of disease which forces people to choose whether or not to pursue their own claim for damages, it could be said that beyond mesothelioma, the only logical step would be to remove altogether the restriction on relatives' rights in Section 1.2 of the 1976 Act. That is not, pause here, that is not a matter for swift legislation and very limited costing and consultation. In other words, there had only been very limited costing and consultation for this short act. At common law, a relative could only claim damages if the deceased could still claim damages at the time of his death. This provision has been enshrined in Scottish statute since 1976. To in effect do away with it, with no appraisal of its rationale, no assessment of the impact on the rest of the legal and procedural framework, and no assessment of the costs to and effect on the insurance provider and policyholders would be unwise and indefensible. Reading on to paragraph 20, ministers do accept that there will be some other personal injury victims whose individual circumstances put them in a dilemma in relation to claiming damages or allowing their relatives to claim. I pause here to mention that lung cancer might be one such condition. They understand and sympathise with the pain and anxiety this may cause. They are clear, however, that they cannot tackle that wider point through this short bill for reasons explained above. They are examining this through the wider look at the continuing appropriateness of Section 1.2 exclusion, which the Scottish Law Commission will carry out as part of the review of this area of damages law. Finally, paragraph 21, the provision would apply as follows. The new provision will apply only where the sufferer recovers damages or obtains a full settlement on or after the date of the bill comes into force. Where the liability of the responsible person has been discharged prior to that date, the discharge will continue to bar any claim by the immediate family. Where the new provision does apply, the immediate family will have the existing limitation period of 3 years after the death of the mesothelioma sufferer in which to make their claim. Now, if I can direct my lords to page 368 and the financial memorandum. 368.
Thank you.
And this comes back to a question I was asked about the inevitability of death. But at present, mesothelioma sufferers, this is paragraph 8, at present mesothelioma sufferers must decide in the closing months of their lives whether to pursue their damages claim while still alive or allow the claim to be pursued after their death so that the family can benefit from larger awards. Under Section 1.2 of the Damages Scotland Act 1976, the claims by the immediate family of someone who dies as the result of a personal injury are extinguished if the injured person settles their own claim before they die. A dilemma arises, and I'll not read on. But at paragraph 9, the intention of the bill is to remedy this situation by amending Section 1.2 of the 1976 Act to enable damages for loss and suffering to be claimed by the immediate family. The bill will not amend Section 1.2 in relation to compensation to relatives for loss of financial support, and then they look at the financial implications of that scenario and not any other wider scenario. So the only financial consequences that were considered by the Parliament for this bill were those involving litigation involving mesothelioma sufferers.
I'm just wondering, when did pleural plaques become actionable? The Scottish Parliament had to overrule a decision of a House, effectively by legislation, overrule a decision of a House of Lords.
Yes, my Lord. Pleural plaques were actionable, or thought to be actionable, at common law, and then in the mid-2000s, under the Rothwell and other cases, they were paused for a number of years.
Well, it was held to be not actionable.
They were not actionable. They were not actionable. And then the Scottish Parliament intervened to say that they were not a de minimis.
So I'm just wondering if the explanation behind the omission of pleural plaques here, or the position of people who don't currently suffer mesothelioma, but who are at risk of suffering from it, might be that it wasn't possible at that time to bring a claim if you were a pleural plaque sufferer.
In the policy memoranda, in fact, in any of the debates, there is no mention of any condition, any other asbestos condition.
No, but it wouldn't be surprising if it wasn't. I'm just wondering, what was the date of Rothwell and what was the date of
I did try and look into this because I had Lord Reid's concern in mind, but it did seem that Rothwell came as a surprise in Scotland, and as far as I could gather, it was contrary to what the law was assumed to be before that, which was the pleural plaques was compensable.
Rothwell,
the Scottish Parliament then overruled Rothwell with retrospective effect, and therefore it wouldn't explain this, right, if that's correct.
Right.
Indeed, Rothwell was reported in the 2008 one appeal cases, but the decision came in 2007, as I understand it. The decision was made in October of 2000. No, I beg my Lord's pardon, I don't know. Actually, I'm going to stop talking there. The last date mentioned at page 1078 is October the 17th on the 2007. I suspect that was the advising, but I don't know. There had been a Court of Appeal.
The judgment was given by the House of Lords in October 2007.
Yes. And the Court of Appeal had heard the matter.
And the legislation overruling it would have been in about 2011. It's legislation that came up in AXA in 2012.
I had understood it was 2008, my Lord, but I may be speaking out of turn. I may be speaking out of turn.
No, you may be right. It may just have taken a long time to get to this court.
But the point, to answer my Lord Reid's question, is that all asbestos conditions...
It was 2009 it was passed.
2009. The logic on the appellant's submission would apply to any asbestos claims and not just to pleural plaques claims. So a claim for asbestosis or lung cancer would also be caught by the logic. So it is not merely pleural plaques that would have been in the Parliament's mind. They would have, when they were talking about other asbestos conditions, they were thinking about pleural plaques, diffuse pleural thickening, asbestosis, lung cancer, not just pleural plaques. So much for the purpose of the Act. The purpose of the Act was to relieve the dilemma facing mesothelioma sufferers. And the explanatory notes, which are to be found at page 353, and I won't take the court to them unless they wish to, they confirm exactly what was in the policy memorandum. So now, my lords, if we may look at the Act, it's the 2011 Act itself. The 2011 Act is to be found at page 191. The entire Act has been produced so that an explanation can be given as the entire context within which those who face asbestos-related conditions can be shown. There has been a reference already this morning to provisional damages. Relevant as well is Section 1, which is those damages available to an injured person whose expectation of life is diminished. They are entitled to claim for lost years, and that is provided for by Section 1. Under Section 2, there is a transmission of the deceased's rights to the executor. The part of the Act that deals with the rights of relatives to claim for damages is dealt with at sections 3 to 6. Now, Section 3 I would categorise as an introductory provision. It provides certain qualifying conditions. A person A has to die in consequence of suffering personal injuries as a result of the act or omission of another person. That's B. And the act or omission gives rise to liability to pay damages to A or the executor, or would have given rise to such liability but for A's death. We, in any claim involving long-tail disease, are involved with Section 3A. Section 3B may apply principally to cases where there is immediate coincidence between the wrongful act and the death, such as a fatal car crash. Now, the liability in my submission is expressly the concurrence of the act or omission and the personal injuries. And as I opened, what there is compensation for is at the heart of that.
So, in your submission, was Mr. Crozier within this section or not?
Because this is an opening provision, in my submission, Mr. Crozier's case would have passed that, but would have then failed at Section 4.2. I don't, in my submission, Section 3 is not gatekeeping to that, to the extent of excluding Mr. Crozier's claim as such. But he is, in my submission, clearly caught by Section 4.2. It's at page 196. So at Section 4.2, except as provided for in Section 5, no such liability, and that's a referral back to Section 4.1 and on to Section 4.3, no such liability arises if the liability to pay damages to A or to A's executor in respect of the act or omission is excluded or discharged, whether by antecedent agreement or otherwise, by A before A's death. We don't need to read the next part. So in my submission, Mr. Crozier's claim had been discharged and no such liability arises. And the liability...
Well, the liability was discharged.
Indeed. Yeah. The liability was discharged, and that was all liability consequent upon the pleural plaques claim, so that the defenders were no longer liable to any extent to anyone arising out of the wrongful act or omission.
Well, I think that's common ground, subject to the exception.
Yeah.
But in my submission, that provision, the liability for pleural plaques, that having been discharged would also defeat any referral on to Section 5 and any use of the exception by relatives. This is, after all, a subsection in a provision to deal with relatives' claims. And Mr. Crozier's claims for pleural plaques had been discharged. Now, if we read on...
You keep saying his claim. It's not claims that are discharged, it's liability that's discharged.
I beg my Lord's pardon. It should be that the liability has been discharged.
And I'm not sure why you say... I mean, if you're saying that it's a liability to pay damages restricted to pleural plaques, I'm not sure why you're saying that.
The reason I'm saying that is because the liability involves the concurrence of the wrongful act or omission and the personal injury. And the personal injury, in Mr. Crozier's case, was pleural plaques.
I mean, if the liability to pay damages in respect of mesothelioma had not been discharged, then I'm not sure why we're here.
All claims, including those for mesothelioma, had been discharged by the discharge of Mr. Crozier's claim. So, in my submission, there was no... Mr. Crozier could not come within...
We're getting awfully confused conceptually here. Section 4.2 is concerned with a liability to pay damages in respect of an act or omission. And Section 3, similarly, is concerned with an act or omission which gives rise to a liability to pay damages. So the act or omission is the exposure, in this case, it's the defender's exposure of Mr. Crozier to asbestos without a negligent exposure.
I accept that as far as it goes, my Lord, but I would say that if one looks at Section 3, then there has to not merely be an act or omission, but there has to be the suffering of personal injuries.
Somebody has to die in consequence of suffering personal injuries. So here, the relevant injuries is the mesothelioma.
Quite.
So that's what he died in consequence of suffering.
Well, but the liability was not in respect of mesothelioma. The liability was in respect of his claim for pleural plaques.
Well, there's nothing about that in Section 3.
But there wouldn't be, because the exception is the narrow one for those who are mesothelioma sufferers. They are the only ones who qualify under Section 5.
Well, we haven't got to Section 5.
No. But if one were to look at that, then look at Section 3 without looking any further, then Mr. Crozier would not qualify under that heading when he settled his claim for pleural plaques.
He hadn't died then, so of course he wouldn't.
You've accepted, though, that when I asked you accepted that Section 3 does cover Mr. Crozier.
Indeed. So,
I mean, you might have sought to develop an argument that it doesn't, because it only applies to people who had the personal injury from which they die or something at the time of settlement. But he's within the whole scheme of this, and then he must be within Section 4, because you rely on that as otherwise extinguishing liability, don't you?
He must come within Section 4.2 only for the purpose of extinguishing his liability.
Yeah. Well, the question, it's all about, isn't it, whether the exception in Section 5 applies or not. That's the only issue.
Well, Section 4.2 refers on to Section 5.
Yes.
There is an exception within...
Exactly. So that's the whole argument is about whether the except as provided in Section 5 applies or it doesn't. Apart from that, it's common ground, isn't it, that if it weren't for that exception, if it applies, then Section 4.2 would operate here.
Well, indeed, but I think the respondent's position would be that the operation of Section 4.2 would still allow the relatives to come back to court for damages. That's their point, and we say it simply doesn't. The discharge of the one action that Mr. Crozier had eliminates everything downstream.
I think they accept
Sorry.
it.
But that includes the relatives' claims. That includes the relatives' claims, and that is not common ground.
So you're saying that they don't rely on Section... They don't need... On their case, they're not... It isn't entirely dependent on Section 5. They're arguing anyway that even apart from Section 5.
Well,
I don't think so.
That's merely more a matter for Mr. Milligan.
Well, it is,
He's
yeah.
shaking his head.
But
It's certainly not an argument that seems to have surfaced in the courts below, to judge from the opinions.
the appellant's position has always been that Mr. Crozier did not come within the exception, and neither did his relatives, and that the claim had been discharged, and that one claim having been discharged, the relatives have no further rights to come back to court.
Yeah, well, yeah, because 4.2 is all about, it's all about a liability to relatives. Subsection 1, B is liable under this subsection to pay to any relative.
Yeah.
2, no such liability, i.e. no liability to relatives, arises if the liability to pay damages to A, that's the Section 3 liability, is discharged.
So you have to rely on Section 4.2. You do rely on it, don't you?
Yes, and I do.
Yeah.
And I say that Mr. Crozier's claim is considered by Section 4.2 only to then prevent any claim by him or his relatives, well, claim by his relatives, not even by him, by his relatives. Because if I may develop that further, liability is not abstract. Liability is for negligently causing a particular personal injury. And the notion of the liability in Section 5.1, as we'll see, is central to the understanding of both the exception and the error in the courts below. In my submission, the liability for the pleural plaques does not trigger the Section 5.1 exception, and it cannot do so. Only the liability for mesothelioma does. And if we can look, please, at Section 5.1, the place to start in my submission is the heading. And my learned friend, Mr. Campbell, has already dealt with the headings. It cannot be ignored that the heading is for a discharge of liability to pay damages, an exception for mesothelioma. And that exception for mesothelioma has to work through all of the section. It cannot simply be selectively read only for Section 5.1b or the like. It has to be...
But it is an exception for mesothelioma, whichever argument is correct, isn't it? Because it only applies to people who die from mesothelioma. So I don't really see how the heading advances your argument.
Well, if I may respond to that, my Lord, Section 5.1a does not deal with the death from mesothelioma. Section 5.1a deals with the liability.
Yes.
Yeah.
And Mr. Crozier, he had no liability, or there were no liabilities to Mr. Crozier for mesothelioma. They had been discharged, and the relatives cannot inherit a better right than Mr. Crozier had.
But that's why A applies, because the liability was discharged.
acknowledges that, according to the law as it stood immediately before this came into force, the relatives have got no claim. But then section 5.2 essentially creates a statutory claim if the conditions in 5.1 are satisfied.
Well, the appellant's position, Lord, is that the liability for a different condition having been discharged, Mr. Crozier did not come within the exception for mesothelioma.
But this argument is against you. Is against you because if a liability, if there was no discharge of a liability to pay damages in respect of mesothelioma, then there's no problem about the relative's claim.
You wouldn't be within 4.2.
It is only in my submission, when one looks back at the purposive interpretation, it is only if a person was a mesothelioma sufferer when they discharged their claim that they come within section 5.1. That is the...
Well, why, if that were correct, why wouldn't that apply to 4.2 as well, which uses similar language?
Well, the context is different, and the context is all. The context is in section 4.2 is for any liability other than for mesothelioma, and that is why Mr. Crozier's claim hit the rocks of section 4.2, and his relatives could not claim any further. And the respondents' attempt to bring themselves within the exception of 5.1 in my submission also found us on the rocks, because Mr. Crozier was not a mesothelioma sufferer on any view when he settled his claim.
So really, you need to put an additional paragraph into section 5.1, perhaps between A and B. A was suffering from mesothelioma at the time of such discharge.
I say no, Malone, because the liability can only be understood as a liability for mesothelioma.
Yes, well, we've been round that tree already. The problem is you have to have you require A to be suffering from mesothelioma at the time when the liability is discharged, and that's not expressed. So you have to, in some way, read that into 5.1a, I think.
I agree, and that is the appellant's point in a nutshell. And where the appellants look for support for that is in the heading that the liability in section 5.1a has to be different from the liability in section 4.2. They both refer to the concurrence of a wrongful act and a personal injury, but they refer to different personal injuries. So while the term is the same, the context is entirely different. And
the problem with that is that section 5.1a doesn't tell you what the liability is.
No.
So you have to look back, don't you, to see where that comes from, and that comes from section 4.2.
If I may put it this way, my lord, in terms of the gates that would have to be crossed to be eligible, if somebody if somebody has pleural plaques and then dies from an asbestos condition, they may pass the section 3 gate. If they have passed the gate of section 3, they would then have to also pass the section 4.2 gate. Now, somebody who has mesothelioma and hasn't previously discharged a claim would pass the section 4.2 gate. Somebody with pleural plaques who then dies of who's discharged the liability would not pass the gate at section 4.2. The only people who pass the gates and then clear section 5.1 are those who come within the exception for mesothelioma.
But if the difficulty for you is if the person with pleural plaques doesn't pass the gate at section 4.2, that, leaving aside the exception, then they're within 4.1, and then there's a liability to pay the relatives.
Yeah.
Depends what you mean by pass the gate.
Yes.
But if by pass the gate you mean get caught by, it's essential to your case, isn't it, that the person who has only got pleural plaques but enters into a full and final settlement is caught by section 4.2 unless section 5 lets him off.
But that can't be the case for somebody who has pleural plaques and then dies from mesothelioma.
Well, if they're not caught, well, if you don't say that, and you go down the other route and you say they're not caught by section 4.2, then they're within, subject to the exception, then they're within 4.1, and you lose that way.
But we say they are caught by section 4.2. Mr. Crozier was caught by section 4.2. That's what
we thought you said.
Yes, yes.
But he's caught by 4.2 only because he comes within 5, according to you.
No,
I mean, not because he doesn't come within. Is that right?
He does not come within the exception in section 5.
Therefore, you say he's caught by 4.2.
Yeah.
Yes, he's caught by 4.2. Yes.
But that then simply takes you back to looking at 5, where there isn't, as my Lord Reed said, any condition that he was suffering from mesothelioma when he settled his claim. And speaking for myself, I don't see how you can get that from the heading, because the exception is the exception from a liability to pay damages, rather than an exception for people who are suffering from mesothelioma when they settle their claim.
Yes. But on no view did Mr. Crozier come within that narrow exception. The exception is a narrow one, and it is only, if one looks at the policy documents and the financial memorandum and the heading, it is only for those who were suffering from mesothelioma at the time. And so simply, well, when he failed to pass section 4.2, when he was trapped by that, in my submission, he had no liability for mesothelioma at that stage. It's the liability for something that is important, and that it is only that limited class of people who are mesothelioma sufferers, who have a claim for mesothelioma, who die for mesothelioma, that come within section 5.1.
It seems to me you've got the double difficulty that you first have to read some words into section 5.1, but then you also have to avoid reading similar qualification into 4.2, despite the fact that it has parallel language.
But the context is different, my lord, because the narrowness of the exception for section 5.1 only captures the small category of people that I've referred to. It's not a wide category, everyone who fails. That would destroy the exception. And the context of the use of the words liability and what that liability is for is essential. So the term is the same, I accept that, of course I do. But the context is materially different. So who is covered by the context for section 4.2? I say that must be those in Mr. Crozier's case, whereas those who have mesothelioma and who raise a claim and then discharge a claim for mesothelioma clearly come within section 5.1. And Mr. Crozier is not in that class.
So if you have to read words in, I know you say you don't, what would they be?
I can't answer that. I don't need to.
Well, I thought you did in your case, actually. You said if you need to, you can put in full mesothelioma.
Well, that is in the written case. My Lord has reminded me. It is. And I had omitted to remember that. I would simply refer back to the written case.
78.
78.
39.
I do beg my Lord's pardon for that. Sorry.
Yeah, even that doesn't quite get it, because obviously there was a liability for mesothelioma that was discharged.
It should be to someone's, would do better to insert to somebody suffering from mesothelioma, I think.
Yeah.
Lords, before I finish, as I will do shortly, may I return to the written case, as my Lords have it open. At paragraph 75,
Page.
I beg my Lord's pardon, I'll just turn that up. At page 39.
Thank you.
Now, here I deal with the error by the inner house. And I simply refer to this to put it, to put the appellant's case beyond, well, what I would say beyond doubt. Paragraph, I do here refer to the heading of section 5, and that the exception for mesothelioma detailed in the heading ought to be applied throughout the section, as I've said. To do otherwise would be to ignore the heading. Because if one were to ignore the heading, then where would that leave the heading? Why would there be a selective application of the heading in my submission? The error by the inner house was primarily concentrating on the death from mesothelioma rather than from the nature of the liability. Now, I'm conscious that we have discussed the nature of the liability, but the error relates to the emphasis on the death. Now, there's no doubt that Mr. Crozier died from mesothelioma, but the fact that he died from mesothelioma does not help with the interpretation of section 5.1a, or what the liability in that context means. Now, the fact that there is a reference in section 5.1b to the death from mesothelioma makes sense to avoid any consideration of there being death from another condition. So if somebody had mesothelioma but died from lung cancer, they would not be caught. And that is the true significance of section 5.1b in my submission. I do refer to external aids for construction, and I have referred to some of those, in particular the policy and the financial memorandum. If I could turn to the Scottish Law Commission, please. If my Lords would forgive me just a moment while I turn up the Scottish Law Commission. My numbering has gone wrong. Yeah, 1192, please. Now, apologies for dotting around just a little. This, the Scottish Law Commission memorandum came about after the 2007 Act and before the 2011 Act was enacted. And my Lords may remember in the policy memorandum there was a discussion about whether there should be a wider a wider change to the law. And in the Scottish Law Commission's analysis, they were of the view that there ought not to be any wider change. In the Scottish Law Commission's recommendations, recommendation 8 at page 1192 is the right to sue on the death of a relative should continue to be extinguished if before he died the deceased had discharged the responsible person's liability to him or his executor. That is the dominant rule. That is the default rule in a case where somebody has discharged their liability, and the appellant submits that that is the rule that ought to apply in the present case. There is then, at paragraph 3.24, a consideration by the Scottish Law Commission about the exception to the general principle, and that is in cases of mesothelioma and the exception that is raised by that. At paragraph 3.25, it is said, in the discussion paper, we asked whether the exception could be made non-disease specific. We suggested that section 1.2 of the 1976 Act could be disapplied and relatives would retain their right to sue for non-patrimonial loss if the deceased died within 3 years of the beginning of the limitation period. And then they said, for example, A suffers an injury caused by B and the prognosis is terminal on the assumption that the limitation period begins at the date of diagnosis. A must raise his claim within 3 years. A settles his claim a year later. If A dies from personal injuries within the triennium, the relatives would retain their right to sue for non-patrimonial loss. They then record the mixed response to that, and they then, at paragraph 3.27, state that by contrast with many other diseases, when mesothelioma is diagnosed, the prognosis is certain and death will inevitably follow after a short period. As the disease is caused by exposure to asbestos, there appear to be no multiple causative factors. Therefore, the defender's liability can be established relatively easily. This makes mesothelioma cases highly exceptional. At present, there do not appear to be any analogous conditions which would merit a similar exception, or at least there is no apparent agitation by the public that further exceptions should be made. Reading on to paragraph 3.28, we are convinced the special features of mesothelioma justify the intention of the exception to the operation of section 1.2 of the 76 Act. It is not thought that there is a present need to extend such an exception to other diseases or personal injuries. Even if it were simple to formulate, in our view, non-disease specific exception is not required. The special nature of mesothelioma cases has been recognized in other areas of law of reparation. And they then make the recommendation at paragraph 9 that where a victim dies of mesothelioma, his relatives should retain title to sue for non-patrimonial loss, though the victim has excluded or discharged liability before his death. In the context of that analysis, again, the Scottish Law Commission reaffirms that the exception only applies to those with mesothelioma.
No, it doesn't say anything of the kind. I'm afraid I don't think what you read to us supports your proposition.
Perhaps
everything is focused on the cause of death and nothing on the question whether he was suffering from the condition when he discharged the claim.
Well, if my Lord turns back to paragraph 3.24, the bit that I didn't read, at the top of page 1193, when the prognosis is that he will not die from the personal injuries until a substantial period of time has elapsed, it seems clear that any settlement should relieve the defender from the relative's claims. It should also be noted that the longer the victim lives, the more difficult it becomes for relatives to establish that he died from the personal injuries and not from any other cause. The hard case is when, as with mesothelioma, the victim dies within a relatively short period after diagnosis. That is the mischief. Here, the defender will not be faced with claims by relatives years after the victim's claim has been settled, yet if the victim settles, he prejudices his family as they will lose their right to sue for non-patrimonial loss as well as loss of support. However, as mentioned above, the Rights of Relatives to Damages Scotland Act 2007 addresses this issue in the case of mesothelioma victims by providing an exception to the general rule whereby the victim's settlement does not extinguish the relative's right to such non-patrimonial loss.
But again, they're talking about someone who is a victim of mesothelioma, i.e. who dies from it.
In my respectful submission, they are not merely talking, they're not merely referring to that. They are referring to the discharge of liability by someone with mesothelioma. They are not merely referring to the mode of death. Yes, and only those people with mesothelioma face that dilemma. Nobody else does. Mr. Crozier did not. Now, I'm conscious of the time, and I can finish before lunch. I would refer, in case of ambiguity, there is one passage, and that is by Johan Lamont, who was a minister, that can be referred to in the event of there having been in the event that there is a liability. Now, under the heading of ambiguity at paragraph 22, no, that's my 22.
Well, you quoted this in your case, I think.
Yes. In the event of an ambiguity, it is...
Doesn't seem to add anything to what's already in the case memorandum before which we can look at anyway before the legislation was...
No, indeed, but that in my submission, what it may add in the event of an ambiguity is that under Pepper and Hart, if there is going to be some consideration about whether there is an anomaly or an ambiguity about what the liability in section 5.1a refers to, then one can look at Johan Lamont's statement to the Scottish Parliament, and it does confirm that the mischief is the dilemma, and that the act, which is a short act, is only designed to relieve those who face that dilemma.
And just so you understand, I'm looking to see what the ambiguity is. If it's anywhere, it's got to be somewhere in section 5.
5.1a, my lord. I think if there is an ambiguity, is what is the liability? Because as has already been mentioned by my Lord Legate, the term liability features, or the liability features in section 3, section 4, and section 5. Now, I say that the interpretation of the liability has to be seen in context. It's the same term, but a different context has different effects. But if there is any doubt about that, then one can turn to the ambiguity there about what the liability refers to in that context. And in my submission, the significance of Johan Lamont's statement is clear, and because it satisfies the 3 parts of Pepper against Hart. That is the only exception that is to be covered by section 5.1a.
And just so that I've got this clear, you are therefore having to say, aren't you, that liability in section 5.1a means something different and more narrow than, quote, such liability in section 4.2.
I'm so sorry, my lord, I missed the beginning of my last
You're having to say, therefore, as I understand it, that liability in section 5.1a, which is where you say the ambiguity lies, means something narrower than no such liability in section 4.2, so far as mesothelioma is concerned. Because if it doesn't mean something narrower, you either are outside 4.2 and 5.1, or you're inside 4.2 and 5.1.
Section 5.1 has to be considerably narrower than section 4.2.
I'm just talking out the word such liability in relation to mesothelioma. Because obviously 4.2 and 5 are meant to be read together, since 5 is actually referred to in 4.2.
Yes. No such liability must refer to the liability to pay damages to relatives, as is seen in the heading of Section 4.
Yes, but so far as mesothelioma is concerned, you say, as I thought, that includes a liability in relation to somebody who settled when he hadn't got mesothelioma, but you say when you get to it in Section 5, it only refers to somebody who settled when he had got mesothelioma.
Quite, exactly, yes. Yes, I've recovered my numbering, and the anomaly that is referred to is to be found in paragraph 24 of the written case, which is at page 16. And the anomaly, the unprincipled anomaly, which is, as we've discussed under the consideration by the Scottish Law Commission, would result in different outcomes for different classes of people if the respondent's argument is correct. And if I can simply...
I mean, there's already an anomaly, if you like, because somebody who dies from lung cancer, being exposed to asbestos, doesn't benefit, where someone with mesothelioma does, and they might die within just a shorter time within the disease developing, and they're outside the exception, and that can be regarded, from one point of view, it is as anomalous.
Well,
it's a policy choice that's been made.
Policy choice, but that policy choice prevents that anomaly from being an unprincipled one, because Parliament has decided, following debate, that there are exceptions for mesothelioma, and that that exception is as narrow in my submission as stated by the appellants, that it is for mesothelioma sufferers who have discharged a claim and who then die, or their liability, and then die from mesothelioma. Now, very conscious of the time, I will leave the analysis of the errors to the written case, which are, I won't improve or expand upon. Those are the errors that the appellants say that the courts below made.
Yes, Mr. Mackenzie.
Unless I can assist the court further.
Thank you very much indeed, Mr. Mackenzie. We'll adjourn for a few minutes just to consider where we are, and if counsel will bear with us, we'll be back quite shortly. Well, we're going to adjourn in a moment, but when we resume at 2 o'clock, we would like to hear you, Mr. Milligan, and we would be particularly assisted by, I appreciate you've got a lot of experience of this type of case. It would be very helpful for us to have a practical idea of how these cases are actually dealt with in the courts, or by settlement between parties. And we're particularly interested in paragraphs 26 and 27 of your written case.
25.
Sorry? 25. I beg your pardon, 25 and 26. And we would like to have a better understanding of how provisional damages actually operate in relation to asbestos-related cases.